State, are you ready?
Yes, Your Honor.
Defense, are you ready?
Yes, sir.
Okay. Ms. Maxey, the panel is yours.
Thank you, Judge.
And 25 minutes for each side. You may proceed.
Good afternoon, everybody. Apologize for those little bit of technical difficulties. My name is Julie Maxey, and I'm the prosecutor in this court, the County Court of Law 2, in Jefferson County, Texas. And I represent the state in this case, and it's my honor to represent the state. I wanted to say before I started, thank you so much for your willingness to show up today. Thank you for your patience out in the hall. I know you guys have been sitting for a long time. And thank you for bearing with us through, like Judge said, a little bit of musical chairs. We just want to be able to make sure that we get to know you and not the wrong name on the page as we're looking to talking to you. Because that's why it's important that you sit in the right spot. So I want to go through everybody that is either up here with me right now or is a potential witness in this case, just to make sure that none of us know each other, or if we do, if that's going to be an issue. So does anyone know Benjamin Steele, who's the defendant in this case? Jansen Bailey is the defense attorney. We'll have Michelle Beha. I anticipate that she'll be a witness. Also, Kelsey Lewis, I anticipate as a witness in this case. Does anybody know her? Julie Maxey, that's me. Does anybody here know me? And then lastly, we have Mr. Raymond Shear, the inevitable Raymond Shear. Does anyone know Mr. Shear? Okay, now that we're through with that part, I want to talk a little bit about the actual law in this case. So as you heard Judge say earlier, this is an assault family violence case. And I wanted to show you guys the statute. So a person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to another, including the person's spouse. Now, the burden of proof in this case is carried by the state. And I think you guys probably got a little bit of this in board hour yesterday, so I won't spend too much time on it. But it's the state's burden in criminal cases to prove the elements of the crime. And so this is something that we embrace. And it is my job during this trial to prove the elements of the crime beyond a reasonable doubt. It's actually, the defendant doesn't have any burden to prove at all. They don't have to prove anything. My job is to prove the case. Next, let's talk a little bit about what it means to find someone guilty beyond a reasonable doubt. That doesn't necessarily mean beyond all doubt. It's beyond a reasonable doubt. And so we ask when you come in here, if you wouldn't mind keeping your common sense with you. only you can decide, once you hear the evidence, if something has been proven beyond a reasonable doubt. And the Supreme Court says that I can't give you a legal definition for it. It's something that you have to define for yourselves. So I want to ask a series of questions just to get to know everybody. I want to know who is going to be a good fit for this jury. And I showed you the law, and you don't necessarily have to agree with the law, but I want to know if you can follow the law in this case. So when I ask questions, because of the nature of the crime, I might have to ask some sensitive type questions. If you come across anything that you want to talk about, but you don't necessarily feel comfortable talking in front of this room of people, we are happy to speak with you privately afterwards. Just let us know, okay? So to start out, this is one of those sensitive questions. Has anybody here been a victim of violence in the past? What about a friend or family member? Have any of you had a friend or family member be a victim of violence, maybe specifically domestic violence in the past? Yes, Mr. McGinnis.
My daughter, my son-in-law.
Okay. And knowing that and experiencing that, would you be able to set that experience aside and be fair and impartial to both sides and follow the law in this case? Yeah. Okay, thank you. Mr. Ford, do you think that violence, or there could be situations where violence is an okay way to solve an issue?
No.
Not at all?
Repeat that question.
Are there situations where violence is an okay way to solve the situation?
Oh, yes, if you're being assaulted yourself.
Okay, so self-defense?
Yes.
Okay, can anybody else think of any other situations where they believe violence would be an okay way to solve an issue? Ms. Williams, how would you describe what an assault is?
When you cause injury to someone else,
Okay.
Either with your hands or an object or something.
Okay. So let me get a common consensus. If someone is maybe shot with a weapon, stabbed with a knife, something like that, would that be considered an assault in your mind? Okay. We can just do maybe a show of hands. So how about if somebody punches someone else, would that be an assault? Raise your hand if you think it is. Okay. What if somebody punches somebody and there's not a visible injury? Is that still an assault? What if I push somebody? Is that an assault?
Depending on the situation.
Okay, Mr. Trahan, talk a little bit about that.
I've had situations where I've had to separate myself from somebody by a push, so I don't find it like an assault if you're using it for the purpose of self-defense.
Okay. Does anybody agree with Mr. Trahan? Okay. So there can be instances where maybe you're using a bit of force to remove yourself from the situation.
I think it comes to injury.
Okay.
Because you can push someone and not injure them. But if you push them in the wall or they fall down, then they're injured.
Cause pain,
Okay.
psychological trauma. You might not have any physical, but you can have internal pain or psychological trauma.
Okay. Does anybody disagree with Mr. Becerra that an assault has to have a visible injury, or can it be an emotional injury or something that's not necessarily visible to the eye? Can that be the result of an assault? Okay. see. Ms. Fritida, what does, let me ask this. Who would you characterize as people involved in family violence? What family roles would you describe them as? Maybe
a father or mother, son.
like maybe a husband and wife?
Yeah, or it could be a parent, child.
Okay. What about,
Siblings could,
that was gonna be my next question. Could it be a brother and sister?
yeah.
What about, and I'll ask Ms. Littles, can family violence apply to a couple that's in a dating relationship? So you said, yes, you think so? Okay. Does anybody disagree with that family violence should not apply to dating relationships? Mr. Pizarro.
Well, if you're not domiciled together, there's no common law marriage. It's far more of just a simple assault or battery.
Okay, and so what if they're dating and living together but not married?
Maybe it's battery.
Okay. And I heard somebody speaking over here under the breath of the
I was just saying if they live together, it's more of a family.
Okay. So if they share a
If they're just
residence,
dating, I mean, we don't know anything about these people, so if they may have only been on 2 dates, that's just, you know, 2 people.
that was gonna be my follow-up question. What if it was their first date? And there was an assault that took place? Would family violence apply then? That's kind of a gray area, right? You guys were talkative group. Thank you. I appreciate that very much. Let's see. Mr. Milton, is alcohol an excuse for committing a crime? So are you willing to say if somebody's been drinking and they get in a car accident, the fact that they were drinking isn't a defense to that? And Ms. Williams. Right here. What about in an assault situation? Would alcohol be an excuse for that behavior? Okay, talk a little bit about that.
First of all, alcohol should be. I think that alcohol is not alcohol that they can.
Could you speak up, please? Your mask is causing me, I can't hear you.
Alcohol. I think that alcohol, when a person is drinking alcohol and they've had too much, I think it's no assault to me.
So it wouldn't be an excuse for that behavior?
No.
That are it's drunk, I guess.
No, because they say if drunk or whatever. I just don't believe in that.
Okay, thank you. Does anyone believe that for someone to become violent, they must have been provoked? Or are there instances where someone can become violent unprovoked? Let me ask Mr. Berry. Okay. Can someone become violent unprovoked?
Yeah, they can become violent.
Okay. Someone maybe with a violent temperament.
It could be someone who PTSD. They could just have issues that day. First person being
And would that be an excuse for an assault?
No.
Rushing. Can you think of a reason why a victim might stay in a violent relationship? I'm sorry.
Why somebody would stay in a violent,
Yes, ma'am.
the threat of leaving, false security.
Okay. Can anybody else think of any reasons why? Okay.
They tell them that they couldn't find nobody else, so they insecure.
Okay. Yes.
A lot of times it happens slowly. They reveal the violent behavior and being dominant slowly, so they're kind of acclimated to it. And then all of a sudden they found themselves in an abusive relationship, don't know what to do, and feel like they're stuck and trapped. They'll just stay.
Yes, that's right.
The victim is financially dependent on the.
Might be somewhat of a Stockholm syndrome where they begin to feel like maybe that person is right, I deserve this. They lack confidence, financial support, have no other family support, and they might feel like this person could change. Maybe it's my fault. Maybe just give me another chance.
What about I'm gonna love the violence out of this person, right? So thank you for sharing all those. I think everybody shared some really good stuff there. I want to talk to, let's see, Ms. Ferguson. What do you think about someone who stays in an abusive relationship?
I would hope they would see the problem and seek help to get out of that situation. It's mainly up to them to figure out if that's what they need to do.
Okay. Does anybody else have some thoughts? What would you think about, let's see, Ms. Marchand, what would you think about someone who stayed in an abusive relationship?
There's just no confidence that they can step out on their own and do what they need to do. Well, weeks around, they need help to get out of that situation.
I just have a couple more questions for you guys. The law says that if I just present one witness that can give you evidence to each of the elements of the crime, that's enough to find somebody guilty. And I want to know if there's anybody in here that would have a really hard time finding somebody guilty if they just heard it from one witness. Maybe you feel like, oh, that's not quite enough for me to satisfy that guilty on a reasonable doubt standard. Does anybody feel that way? Yes, no.
I feel like it might be possible that it would be hard to believe just one witness, because if that person is bitter towards the other person, they could be making it up.
Okay. So just the words themselves without any other evidence, you would probably have a hard time.
I'm not saying that I probably would. I'm just saying that I could have a problem with that, because if they genuinely hate that person and they're trying to get them in trouble, they could be making it up.
I would agree with that, and I would say evidence. And we'll probably say,
okay. So who else agrees with that? Let me see a show of hands. Okay. So you would want to see with some evidence. You would need some evidence to look at instead of just the word of one person. Does anybody have any religious or moral reasons why, even if you believe somebody was guilty, that you couldn't find them guilty? Does anybody hold any of those beliefs? Okay. I believe that's all I have. And I want to thank you all again for your jury service. We appreciate you really coming to this tonight. So thank you very much.
Billy, panel is yours.
Good afternoon, everybody. My name is Jansen Bailey. I'm an attorney from Beaumont, Texas. I went to high school in Beaumont, and now I work in Beaumont. Mr. Steele, Benjamin Steele, was a student of mine while I taught math at Westbrook, because before I went to law school, I taught math at Westbrook High School. Today we're here seeking the truth. We want to know what happened, what didn't happen, and why people saying some things might have happened that they didn't. That's why we're here. This process is called voir dire. It's a process of deselection. They used to say it's a process of selection. It's not. The meaning, the more that you talk, the more likelihood you're not getting picked, because you give us more reasons to strike you. So if you want to go home and not come back, speak up. In doing the selection or the deselection, what we're really trying to do is trying to parse out bias, right? Because every person, it's a constitutional right, he's entitled to a fair trial. And in order to do that, it has to be fair and impartial. Some people fit better for some cases, some do for others. For instance, your home had just been burglarized last night. You show up here today and he was charged with burglary. Do you think you would have been a good potential juror? Probably not. Probably because you had a little bias towards the case that was being tried. We'll talk about it throughout the process, but the state, in order to convict someone of a criminal offense, the state has to prove beyond a reasonable doubt. It's the highest standard in our country. To give you perspective, in order for your children to be taken away from you, you only have to have clear and convincing, which is a less standard. In order to sue someone and win for money, you have to have preponderance of the evidence, which is 49-51, which is less than the two that I just mentioned. So this is in order to take someone's freedom, to mar their reputation, and it has to be, that burden is just a very high standard. And I'll continue to talk about that and touch on it throughout the trial. How many of you have heard, someone is innocent until they're proven guilty? Is that the common phrase? Have y'all heard that?
Yeah.
And I always wondered why they say that, because it's really innocent unless proven guilty, not until. Until is a qualifier. It makes it sound like, well, until that amount of time passes. That's not the reality. So there's a presumption of innocence. Mr. Benjamin still has a presumption of innocence. When all of you walked in here today and you looked over here, you're probably thinking, well, what did he do wrong, right? That's just human nature. If the moment we set a criminal trial or a criminal case, you're probably thinking, well, I wonder what he did wrong. And I tell you this because you kind of have to start unworking that. It needs to be, the state has to prove that he did something wrong beyond a reasonable doubt. How many of you here today, let me just by showing of hands, but in a case like this, where it's one person says the other person assaulted them, how many would require Mr. Steele here to actually get up and testify? If she testifies, are you going to require Ben to testify? How many would require him to testify?
I would like for him to testify to hear the other side of the coin, but the Fifth Amendment says you can.
And thank you, great segue. There are a lot of reasons why someone doesn't testify, right? Advice of counsel, nervousness, but there's a lot of legal issues with that. And so as he sits here today, and as you all observe the trial, and if you're picked or deselected to be on the jury, you cannot hold the fact that he does or does not testify against him. And I need to make sure, because that's a big issue of bias. Here, does anyone feel like they would require him to testify in this case? And if you don't, I really would like for you to raise your hand. Everyone is okay if he does not testify. That's not an issue for anybody. Okay.
Same right.
And you say that, and so the whole point, it's almost a golden rule: do unto others as you would have them do unto you. And I don't want to get biblical necessarily, but when someone is accused of a crime, there's a lot involved in that. And when there's a lot of times that before a person gets to trial, he's been already, accused, he's been adjudicated, and he's already being punished. And I would like for you all to understand that that's not the way that the legal framework is intended to work. He is entitled to competent counsel. He's entitled to trial by jury, and he's entitled to that jury trial to be fair and impartial. Let me just go through the line. How about Jessica Green? Miss Green, has anyone ever told you that, or have you ever been accused of something you didn't do?
No.
You never?
No, I'm a teacher, I'm a nice person.
How many, did you grow up with brothers and sisters?
Yes.
So how many siblings did you grow up with?
Just a big one.
And, well, I guess how much older was he?
4 years.
And he never went and ran to your mother and said, Jennifer, she never.
We're best friends.
Yeah. Well, okay. Has anyone else been put in a situation where something's been said that wasn't true about them? What about, is it Mr. Sorry, this is what I have to look off of. So it's really kind of out of order. Is it Mr. Barry? How did that make you feel?
Well, it makes you feel pretty good. So I think that you did something you did.
And let's ask, moving to your right, is it Miss Williams?
Yeah.
Can you give me a reason why someone might accuse someone of doing something they didn't do? Why might someone say this person assaulted me if they in fact didn't? And let's ask the entire group. So what are motives? What might someone do in order to lie? Like why would you lie and say that this person assaulted you when they didn't? If you're in a dating relationship. Does anyone have any reasons why someone might do that? Anger, resentment, jealousy. So these are all reasons, and there's a list, right, of reasons for why. So I just want you all to remain open-minded. The state is going to put their case on first. We don't have to put anything on. I don't have to have him go up and testify. He's not required to. He doesn't have to. And I might not call any witnesses. The state is the one who has brought the charge. They're the ones who are going to prove the charge. I need you all to understand, who's ever be selected, that if we don't put anyone on that stand, that by no means should be counted against us. Does anyone have an issue with that? Okay, let's talk about evidence. There is a lot of evidence in case. You have circumstantial evidence, you have direct evidence. In this case, you'll have probably pictures. You'll have witness testimony. You'll have someone up there, and so you're looking at pictures, and you're going to hear from witnesses. So those are the two types of evidence I am assuming we're going to see in this case. Would anyone require more than that in order to find him guilty? Let me ask you another way. What evidence would you require in order to find him not guilty? It's a trick question. None. Because as this moment sits, he's already presumed innocent, right? Lastly, thank you for your time. Sorry we got started late today. I don't anticipate this trial taking much longer than maybe tomorrow, maybe bleeding into Thursday morning. But anyways, thank you all for being here and looking forward to putting on or not putting on. Okay, thank you.
Okay, ladies and gentlemen, we're going to ask that you will step out the courtroom into the hallway, and there may be some of you who will be asked to come back in to have the lawyers ask some follow-up questions. So at this time, you're in the hands of the bailiff. Recess. Does the state or the defense have any challenges for causes? Anyone?
The defense doesn't.
The state doesn't.
Okay. So at this time,
Very straightforward.
we'll be